Yeah, no, that's good analogy.
Well, good afternoon, everyone. Thank you all for coming. My name is William Haun. I'm a non-resident fellow here at the American Enterprise Institute. We are honored today to have a good friend, both of the Constitution and, to me, the Honorable Janice Rogers Brown. Before we begin, I should just say that you can email questions to Sophie Roseri at aei.org or use the Twitter hashtag AEI originalism, or at AEI originalism. And after our discussion, we'll be taking audience and online questions. So we're here now because we are just over 50 years past Robert Bork's landmark articulation of originalism in neutral principles and some First Amendment problems. And there he defended originalism as a neutral method of constitutional adjudication that would prioritize a certain theoretical understanding of judicial restraint that focused on upholding majoritarian choices and eschewed the Supreme Court in having any role in expounding on our national traditions and placing ultimately an emphasis very strongly on linguistic theory when interpreting the words in the Constitution and in statutes. And in one sense, this originalism has been profoundly successful in re-anchoring constitutional interpretation around its terms, around the text of the Constitution and the history of those terms. And the law as a discipline has become much more focused on those goals. At the same time, there seems to be a growing sense that a commitment to abstract linguistic theory when interpreting the law, to technical interpretive rules, is insufficient. Insufficient as a matter of authentically capturing what a constitutional provision means, insufficient as a matter of judicial self-restraint, and insufficient in ensuring the foundational prerequisites of American self-government. And thankfully, today, we have a first-class jurist to help us go through kind of where we are in these debates. Because in a world where many judges would now identify themselves as an originalist or a textualist, there's a sense that the focus of the debate is not really on, are you an originalist or are you not? Are you a textualist or are you not? Or are you committed to neutral rules or are you not? But rather, what do you think of the traditions that are embodied in the terms in the Constitution and in the text? And here we have a judge who has spent over two decades of her professional career grappling admirably with exactly that question. Judge Janice Rogers Brown served California for over a decade as a state Supreme Court justice and an intermediate appellate court judge after serving California Governor Pete Wilson as his legal affairs secretary. She then spent over a decade serving our nation with distinction on the U.S. Court of Appeals for the D.C. Circuit right here in Washington. Yet more impressive than her biography is that despite all of the very strong professional incentives not to do this, she came to her own ideas and she has the courage to defend them. Her jurisprudence is one that recognizes that there are norms and first principles without which our Constitution's textual and structural commitments would simply be empty or parchment barriers. Her jurisprudence is one that accounts for John Adams' observation about our regime, that it is made for a moral and religious people and is wholly inadequate to any other because without those prerequisites, any constraint on human passions would be broken through like a whale going through a net. Judge Brown has been able to reconcile that observation with the role of a judge. That is a pressing task now, and I am grateful that we get the chance to have the benefit of her wisdom today. So thank you, Judge Brown, for sharing your time and insights with us.
Well, Will, thank you for that lovely introduction. I think I should leave now.
Well, maybe instead of leaving, we could talk first. Well, like I said, you spent over 2 decades on the bench, both at the state and federal level, and maybe a good way to start off our conversation here would be during that time, what examples might you think of where these kinds of divisions between people who are very focused on the text and maybe rewarding majorities and presuming that that's the commitment of our Constitution totally versus upholding our history, our first principles. Do you have any thoughts, any examples come to mind where that kind of tension played out and how you thought about that?
Okay. Well, let me start by saying that I am not here to trash originalism or textualism. I like to go back to something Leszek Kolakowski says. He says it much more eloquently than I can, but he basically says every good thing that comes into the world, Satan turns to evil, but God turns it back. And so I think, when you look at the calls for, originalism, for going back to the text, those were very good things. Those were very positive developments. And, it was in response to concerns about living constitutionalism. Judges just imposing their will or their predilections because they thought they were wise and because they felt like there were these generalities in the Constitution which were very capacious and allowed them to do with it whatever they wanted to do. And so that clearly was a problem, and that was the reason that it was kind of sent a shockwave through the judiciary and the legal academy when Ed Meese started talking about what should really be happening in constitutional interpretation. So that was a very good thing. I think the problem that we then got into, and I was certainly all in favor of judicial restraint. I thought it was important to understand that the judicial role was quite limited. We were not there to make the law. So all of those things resonated with me. I absolutely agreed with them, and that's how I started off my career. But then you start to see what these supposedly neutral principles deliver in reality. And so one of the really interesting things about that is that you get into these determinations. One that I can think of is a case that we had when I was on the California Supreme Court. It was called Catholic Charities. And it was unfortunately for Catholic Charities, it came after Smith. So that was already an uphill battle for religious liberty. But what happened in California was essentially that the legislature decided, and this is before some very similar things happened later on the federal level, but California, of course, is the leading edge of leftism in the country anyway. So Catholic Charities was a case in which the legislature decided that Catholic employers should have to provide contraceptives as part of the health insurance that they provided to their employees. Catholic Charities took issue with that, but the court that I was on basically said, well, one, Smith applies, which wasn't completely clear, but also this doesn't really infringe. They were able to determine it doesn't infringe on their religious prerogatives. They are being treated just like every other employer, and we have no concern about that. And I think you could look at that case and say that was a pure textualist response. They went through a lot of analysis looking at Smith and all of that, but they basically just looked at the words of the statute. My response was, even if you do this under the California Constitution, or if you look at the federal Constitution, all of them purport to protect religious liberty. And so how do you do that? Don't you have to look at what, what churches do, right? Why we preserve religious liberty. Don't you have to look at whether you can accomplish what you want to do without infringing broadly on those prerogatives and so forth? But the court did not look at that at all. So I think you would look at that and say, well, that was a textualist decision, and it reached a textualist result. But the question was that the right result? I mean, did it really take account of what the Constitution was trying to protect? So,
and that gets to Judge Bork's essay. Obviously, he was making a broader critique in Neutral Principles about the lack of theory in constitutional law at the time, but he used the First Amendment as a specific example because he said its guarantees occupy a central place in our society in relation to how a democracy works, the nature of self-government. And there have been many attempts at the Supreme Court level in different areas to try to define the First Amendment's guarantees around some concept of neutrality, meaning without any kind of regard to ends or first principles. And we see this in the freedom of speech, that we can't make any distinctions between political speech, for example, or religious speech, or graphically violent video games or pornography. We see this in the Establishment Clause, where neutrality would mean taking religion out of the public square, even if these are traditional expressions of the culture of the area. We see it in free exercise, where neutrality means we don't accommodate religion unless a majority wanted it to. I think the courts moved in all of these areas, but this neutrality still plays a huge role in how lower courts think about the law, and state courts too. And I'm wondering, just given your experience, how did you see that playing out in your time on the bench? And do you think, as a cultural matter, has this commitment to neutrality helped us better appreciate the First Amendment or not?
The short answer is no. But how it's played out in my own career, I have to say that I really struggled with it because I didn't understand where it was going. I mean, to say we just need to make sure that we have the right process and procedures, I think that always sounds kind of attractive. Always sounds, like, yeah, that makes sense. But I think our problem is that, democracy, constitutionalism is much more than procedures, right? So we don't get there with that. But the other more, I suppose, disheartening thing for a judge is to figure out, at long last, I should have figured this out much sooner, but to actually understand, and I feel like my understanding came very slowly, that there is actually no such thing as neutrality. You're actually never neutral. And so what happens is when you say that you are applying neutral principles, it just allows something else to slide in there, right? Because you inevitably, are making substantive decisions. And one of the ways in which I really began to see this is that originalism and textualism were a reaction to this idea of living constitutionalism. But the living constitutionalist went right on doing that. And we ended up, I say, unilaterally disarming. But we did that because I think, this is just one person's opinion, but I think we did that because we actually allowed natural law and unnatural law to be conflated. in the way that we talked about these things. So the first shock that I had was to find that Joseph Story, William Brennan, were both described as natural law jurists, right? So in my mind, there's a real question as to, how do you get, Joseph Story and, William Brennan somehow in the same category as both applying the natural law. And Story talked about natural law. He, would have, I think, been quite consistent with James Wilson, perhaps. But Brennan is a person who simply says, for instance, about the Eighth Amendment, I don't think there should be capital punishment. That's my view, and it is incumbent upon me to make this decision for the community that I think is coming into being, right? So, how is that an application of the natural law? And so that was the first thing that I found really startling, is like, can we not make a distinction between natural law and unnatural law, right? I mean, these things, just because it's extra textual doesn't mean it's an application of the natural law. So, I think that was one of the things that I struggle with. And then I began to see that what was articulated as a neutral principle, where did it get you? And so I'm a big fan of an economist whose name is Tom Sowell. And he said something that really sort of caught my attention, which is, he said, when I started out, I was a really big theorist. But the longer I worked, the more I began to see that what really counted was experience, right? Not the theory you propose, but what does that do on the ground? How does that really work? And so I think I had sort of a similar epiphany when I started looking at the results that you get from these supposedly neutral principles. It began to look like pure majoritarianism and moral nihilism. And it's like, how does that happen? Right? It's supposed to be a neutral principle. It's not supposed to alter what we're trying to interpret. And yet, that's how these cases started to look, right? So.
Now, I mean, judges, of course, they're receiving legal training and they handle legal controversies and not philosophical ones. And maybe they should get philosophical training, but that's not necessarily the case. But it does seem like, though, that we do often insist on asking judges about their judicial philosophy. And so maybe there is something that we could expect that our lawyers and judges learn from people who have carefully understood our traditions, who have looked at the American experience and self-government and what that might mean for the role of a judge and our constitutional guarantees, our statutory protections. I know you've been, over the years, a very careful reader of many, but especially Alexis de Tocqueville and Calvin Coolidge. And I'm wondering, do you think that they or other observers of our experiment in self-government have something to teach judges about how to understand our guarantees?
I think there are a lot of things that people like that could teach judges, but I think it's useful for judges to read widely of everything, but certainly constitutional history and the founding and what the founders were reading. And again, we've got probably the greatest primer on what the Constitution means in the Federalist Papers. And we're very lucky in that regard because most constitutional republics can't look back to something as, specific and pointed as that, even though it was written in a very compressed amount of time with people who were clearly trying to make a point and argue for the ratification of the Constitution. But it now is canon. It's there. I understand now they even have it set up so that you can search every word of it. So there's, it's not difficult for courts to do that. It's interesting that law schools, though, don't look at this sort of thing. And as far as I know, at least the judicial training that I've had tended not to focus on that. And the organizations that really did want to teach about that sort of thing and offered that to judges, it became very difficult for judges to take advantage of that. So it's almost as if there is a sense that if you study, if you want to know the history, if you want to know the philosophy, if you want to know what was happening, that the founders might have been thinking about, how they formed these ideas about what would a self-governing republic ought to look like. There are people who raise objections to that, arguing that it will cause the judges to be somehow biased or tainted just to be exposed to this kind of information. And that seems very peculiar. I think that you would want them to understand as much about it as possible. And I think if they're bright enough to be judges and you're going to, give over to them, a lot of your freedoms, the constitutional guarantees that you hope they will enforce, you ought to think them, bright enough and capable of thinking these things through without somehow being tainted just by coming in contact with this information. But there has been an interesting sort of pushback against that kind of study for judges.
It's very opposite to what Hamilton says
Yes.
in Federalist 78, where you're going to have a long and laborious study
Right.
in Anglo-American legal norms. And you obviously know the founding very well. Is it your sense that the founders were operating on certain abstract theories of, well, the majority always wins, or judges must be clearly...
Clearly not that.
Yeah.
There would have been what's the point of the Constitution if the majority always wins? Why bother?
Yeah.
We didn't even need to go through that exercise. So
some of us might need remedial training.
well, I guess, again, one of the things, I've said this aloud, I'm very honest about it, that I did not go to an Ivy League school. I'm a regular person, and what I learned, I've learned just like all the rest of you, kind of reading it and trying to figure it out. And I said at one point that I had the great good fortune not to be well educated. So, so I think that's helped me actually quite a lot. But my sense of the founders, from what I've read, from what I've been able to discern, from a lot of thinking about this, is that, they wouldn't have been at all interested in the debate that we seem to constantly have. Were they Lockean? Were they Hobbesian? Now I've seen an argument that they were Burkean, and, it goes on and on. They constantly, get into the weeds on, exactly what kind of a regime this was. But it seems very clear they read a lot of things. They were very practical. They were statesmen who were trying to figure it out. They also had, I think, a strong sense of Christian ethics. And so a lot of what we end up with comes through that filter. And there's a part of that history that's kind of ignored because it doesn't fit with the conventional narrative. But Witherspoon, who was at Princeton and taught not only Madison but a number of the early public officials, who were involved with the Revolution and the Constitution making and all of that. They had a very deep sense that divine providence was very involved in what they were doing. So there's much more, I think, of sort of moral depth to them than, at this far remove, we give them credit for. But I think most of all, they were practical. They were trying to figure out how to do it, and they took from whatever source seemed to help them, in creating the kind of framework that they thought would be suited to self-government. But they start off with this idea of human equality, which leads to a requirement for consent of the governed. So they were very focused on self-government, which I think we move away from when we move into all of these abstractions.
Now, maybe one might say in response that, well, employing a look at practice and customs is fine when it's going to give the people more space to address something that's new. And we don't have a clear answer in the text. So we're going to say, let's let people kind of experiment and figure this out before we judges get involved. But the objection would be, it's a different matter when judges are going to be the ones that are kind of expounding the tradition. And you could see, well, then what would you say about a case like Brown, for example, or a case that has to inquire whether, is anonymous political speech protected by the freedom of speech, or are we going to allow a religious accommodation when a majority has said no, we're not going to allow one. I think the objection in those situations from someone who might be more reluctant to look beyond the text would be to say, well, in these situations, judges can't expound on the tradition. They don't have any competence to do that. Is that right? Or what do you think about that?
I don't know. I understand the argument for reluctance. I guess the problem would be if you can't do that, what are you going to use? I mean, on what basis are you going to try to figure out where we go now when it isn't clearly there? I mean, you can't say that it's there. But the problem is you're going to use something, right? I suppose if it were the case that judges simply said, well, it's not there in the Constitution. I don't have any words to interpret. Therefore, my job is done, and it will go back to the political arena.
Right.
And I suppose that might be okay, although it might not preserve the protections for minority views, right?
We have protections in the Bill of Rights for a reason.
Yeah. And so, I mean, I guess one way to deal with it is to say, never mind, we'll let the political process work it out. And sometimes when we're dealing with, debatable moral propositions, maybe it goes back to that. But if you can clearly tell that this is something for which there should be protection, it seemed to me you have to at least say, why not for this, right?
And also, like the nature of our regime, like who are we?
Yeah.
And that, I mean, I think all this kind of focuses on like, if we want judges to kind of better appreciate the prerequisites of self-government when they're interpreting the Constitution and looking at how to understand the text and the structure, then maybe the first issue is how do we form judges well to do that? it seems like it's not a simple matter of, here are the 13 canons of construction, memorize them and you'll do great. It seems like it's more than that. And what do you see as what might be more than that? Maybe something very practical in terms of what law school should be doing, or maybe what we should be looking for when we look for judges in the profession.
Well, we have probably had the greatest sustained attempt to vet judges that we've ever had, we've done okay, but I think not as well as people might have thought, and so I'm not sure what that quality is. I think, and maybe this is very difficult now, I think in some ways it's more like love and respect for the regime, right? And I'm not sure that everybody has that anymore. I mean, one of the things that I think about is this, America was kind of a miracle, right? That it came into being, against all the odds and everything. And it was it was a government where the people who formed that government were really thinking about it, right? Not chance, as Hamilton says, but, something that we bring into being out of choice, reflection and choice. And so, but that was then, I guess, and this is now. And so, one of the things that I think is very troubling, and maybe the founders were aware of it. I mean, we do have a basis, a process for amending the Constitution. So they even accepted that another generation might think differently about this, but we've kind of frozen the Constitution, and we have not amended it, but we have allowed it to be amended by judges, who make these decisions about what something means. It seems to me that if you're going to make those decisions, then, and you haven't amended the Constitution, you have to stay with, sort of, you go with the one who brung you, you have to kind of stay with what they, the framers, thought about those things. And part of that is being able to think, what would have guided them, what were they looking at? And this was clearly a natural law, a natural rights regime then. People may feel now, we don't know the things that they knew, we don't read the things that they read, we don't have the same beliefs that they did. And so maybe there's a thought that, well, we would think about this differently, we would do this differently. I don't know. But at least until then, we have what we have. And so, so people would have to understand that. And I think, I wrote something down, and let me see if I can find it, because I really thought, this is Jaffa, and he says, he's talking about this whole idea of neutrality. He basically says, no one can at one and the same time be a legal positivist and an adherent to the original intentions of the framers. He says, in asking what were the intentions of the founding fathers, we are asking what principles of moral and political philosophy guided them. The crisis of American constitutionalism, the crisis of the West, lies in precisely the denial that there are any such principles or truths. And I think that's how we end up getting to this, this moral nihilism that says, there's no content to anything, And therefore, it's just either what the majority wants or, we can't take any position. But a position is always being taken. So.
Well, love for the regime seems like a good quality to work into.
Maybe it sounds silly,
judges.
but I think you have to, you have to believe in it. You have to think that it is a good regime, that it is important for people to have the maximum private sphere in order to, do as their conscience dictates, that sort of thing. And we've turned that upside down now and established a government which, instead of giving us the space that you see as very much a part of the First Amendment, right? So just leave them alone and let them, figure out what they want to do. Now we have this, perverse situation where the government dictates to us what we ought to think, what we ought to say, what, how everything ought to be done. And that seems to me the opposite of what our Constitution actually encourages and promotes. So, but if you don't love the regime, then you see, that's what the progressives said, right? Woodrow Wilson says, oh yeah, we understand those 4th of July sentiments, but they really aren't about anything, right? So that's part of what's happened to us, is that people who did not love and in fact repudiated the founding ended up being in charge. And about that time is when we invented law schools. And so, so what's being taught, is not admiration for what we inherited.
I imagine there will probably be questions from the audience about 4th of July sentiments and other matters. So maybe we can open up the floor to any questions from the audience. Yes.
I'll go ahead and ask directly about 4th of July.
Oh, yes, and I'm sorry, if you wouldn't mind just announcing your name, affiliation, and have your question end with a question mark.
Yeah, I'm Ben Story. I'm a scholar here in social culture and constitutional studies at AEI. I want to just ask about 4th of July sentiments. Is there something you can point to in your own education or background that can help explain how you came to your own 4th of July sentiments?
Okay. Well, I don't dismiss them. When Wilson said that, he was being very dismissive. He was expressing his contempt for this idea, of all men created equal, self-government, all of those things. And so, of course, being a Black woman, a descendant of slaves, someone old enough to have lived through de jure segregation, Jim Crow, all of those things, I'm not dismissive of those ideas, not at all. My personal experience tells me something different. I probably have an affinity for natural law because if you are me, if your background includes both the Trail of Tears and the Middle Passage, you know that positive law is not enough. All right?
Yes.
Judge Brown. John Vecchione, New Civil Liberties Alliance. And my question is, the neutral, or I would say objective principles, objective approach of the textualists and the originalists, who don't all agree with each other.
Boy, is that true.
So that one thrust of the movement, which I would call the greatest countermarch, Gramscian countermarch through the institutions we've ever seen, was to get the law right. But the other one, I think, and I'd like, this is my question, that any other approach, a natural law approach, when people don't agree on natural law, that it puts too much weight on the judiciary that the judiciary cannot long bear. Either the judges won't be appointed or people will walk away from the judiciary. if they are seen as now out of step with American society. So to the extent that those neutral principles have a weakness in getting the right answer, do they have a strength in not putting more weight on the judiciary than, given how the judiciary is picked, it can bear?
Yeah, the whole process of picking judges has become incredibly political and pretty much a blood sport. I mean, it's an ugly process. So I can see concern about, being able to protect people going through that process, because I think it's gotten so bad now, a lot of people don't even want to contemplate it. But I guess the difficulty is, if neutral principles basically get you nothing but moral nihilism, what have you gained if you get them through the process? I mean, it's a tough problem. It really is. But I think a couple of things have to happen. Which one is that people who decide that that's the profession that they want to pursue will have to toughen up in a sense, because it's not a job you get if you want to be loved. So you can probably just, put that aside and understand that it's going to be tough. I guess the thing that I would say, we can't control the politics, and depending on who's got the majority and all of that, some of these judges, and they might be great potential jurists, are not going to get through. But if we care about America and the first principles that have made America the country that it is, it seems to me we can't take the alternative of saying, let's just protect the people who are going to have to go through this process. Because the one thing that we have to do, no matter what else happens, is we have to stand up for the truth. And we have to just say what that is. I mean, there's no benefit to be gained by saying, well, we know this doesn't work, but we'll continue to profess that just so we can get through this process and get these folks on the bench. So are they dissembling? I mean, are they going to be different when they get on the bench? Or are they going to be the same people who actually have embraced this idea of neutral principles and nothing else? Because if that's the case, I don't think you gain anything. But there's a book out now by Rod Dreher called Live Not by Lies. But Dreher is actually channeling Solzhenitsyn. And Solzhenitsyn writes this essay when he's leaving the Soviet Union. Probably the best thing that happened to him was he got exiled. But a part of this book, there's a person that they're talking to who has stood up to communism and all of that. And that person says, you cannot avoid living in the kingdom of lies, but you must refuse to be complicit in it. Right?
Judge, the point about neutrality makes me think when I remember clerking for you and talking about First Amendment issues and the promise of having neutrality toward the freedom of speech is that if we treat all speech as effectively of the same value, then that means that when a case comes along implicating, say, core political speech, that it would be well protected because we have neutrally said, well, you just can't touch speech. So all speech regulation is going to be looked at with scrutiny, with strict scrutiny, even if it's speech that everyone would kind of understand is not of high value. And yet political speech is some of the easiest speech to regulate, or with religious accommodation with Smith, the presumption was that we cannot trust legislatures with accommodation because they'll be solicitous. The court says that toward religious conscience. Maybe that has been, or maybe that hasn't been the case in 30 years, but it's certainly debatable.
Yeah. Well, I think the First Amendment is one of the most difficult and also one of the most illustrative, right? Because on the one hand, Judge Bork starts out with his neutral principles talking about the First Amendment, right? And he says, it's interesting because he says only political
Right,
speech.
right.
That's all,
Yeah.
and we won't do anything else. And everything else falls by the wayside, and everything else can be regulated, and we can have all kinds of legislation and all of that. That's a very clear standard. On the other hand, though, that becomes, there are lots of speech that is not purely political speech, but still, I would argue, is related to self-governance, right? I mean, things that you need to know, conversations, debates, so things that go beyond that notion of pure political speech. And so, you use the neutral principle in that way. You make the Constitution sort of weightless, right? And I can't remember who said it, but they said basically, you leave out all the moral resonance of the Constitution. And there really is, resonance. I mean, there really are things that are captured there where you can't be so precise.
Right.
But it is, a very good example of that that you can, yes, political speech, that's easy. And unfortunately, our jurisprudence is such that we're stomping the political speech and we're, going way into conduct and lap dancing we protect. And political speech, we hit in the head with a sledgehammer, which is a really weird result, right?
Professor Arcus.
Hadley Arcus, James Wilson Institute, former inmate. Oh, sorry. Thank you. Hadley Arcus, James Wilson Institute, former inmate at Amherst College. Janice, let me draw you into a current argument we're having, and the question of what conservative judges are able to say these days. Some of us were hoping that if we overrule Roe, the court might draw on the findings of those lawyers who argued Roe versus Wade and say, we're dealing with an offspring that has never been anything less than human from its first moments, never merely a part of the mother. We send it back to the states who say, you figure out how the taking of this life will mesh with your other laws on homicide. The alternative is to say, no, we cannot speak to the question of when human life begins. We leave this out to the value judgments made in the separate states as to whether people believe human life begins. Of course, the counter to that is that if it's simply a matter of beliefs, why are you imposing your beliefs on me? And someone says, I walked in here thinking I had a constitutional right. Now you tell me I don't have it because 51% say I can't. And some people think that one reason our judges are reluctant to say it is because they're afraid of providing the predicate on which the Congress could act. And you, as a judge, could act when the protections of the law are withdrawn from a whole class of human beings in the way they were withdrawn from black people. So what's your sense of this thing? Either what holds the conservative judges back, or what you might do which course would you take in this?
Well, I think since I won't ever be faced with that question, I will just say, I guess, and I have not, I should be clear about this, I have not read the leaked opinion. And the reason that I didn't read the leaked opinion is I was so horrified that it was done. And I just felt like I don't want to take advantage of something that was so wrong, even though I'm, of course, very curious about exactly what they did. But it sounds as if at least the opinion that circulated would not go all the way to saying, this is the person and deserves the protection of the 14th Amendment, right? And would simply undo Roe v. Wade, I guess. And so I can't really speak to that. And I don't, there is a part of me that would say, this is a person, we all know it's a person, and it's protected like any other person under the Constitution. Nevertheless, I understand that there are felt necessities where people may decide the better part of valor is not to go as far as you could go. And that's consistent with our history too. That's why we ended up with slavery, right? It was a compromise because, the argument was that ultimately this will reach the point that it needs to reach. And we know this is inconsistent with what we are saying. But we accept that because it's expedient for now. Perhaps in the way this gentleman was saying, to put too much burden on judges. And given that we are now in this situation where any kind of protest is permissible, and that they would have to stand up to that for, who knows how long. I mean, we have not had a situation where the administration has come out and said, that's outrageous, we're going to prosecute people who do that, it's a crime. They're not getting, a lot of protection. So as a practical matter, I understand where they are.
Yes.
Hello, my name is Fahed Al-Wahab. I'm from the University of California, Irvine. I really agree with you about your point regarding natural law and regarding how positive law is limited in a sense, especially given your background. And what drew me into natural law was also, in fact, my background as an immigrant coming from a regime, let's say, that I understood that simply because someone says something's a law, that doesn't mean it's necessarily a law, that there's greater values that we aspire to. However, in regards to natural law, the issue that I really struggle with is crafting a formulaic method that could be replicated. So in your view, what principles, other than the first principle, should judges really be looking into in applying natural law?
Well, I think I'm trying to stay away from the formulaic here. I think that's part of the difficulty. And as Hadley likes to quote Professor Robinson, that he wanted on his headstone, he died without a theory. And so I think maybe we have to resign ourselves to the idea that everything won't fit neatly into a formula. We can't have the 3-point, A, B, and C, and then it will all work out. But we do know what kinds of things natural law encompasses. And we can tell, I mean, one of the things that's been strange to me is that people seem to be unable to distinguish the difference between a judge simply, expressing their particular predilection and someone saying, no, I understand the positive law. And by the way, natural law jurists look to the natural law, and so you can think you start with the natural law. Usually you start with the positive law. Natural law comes into it if there is an argument that this violates, somehow the natural law. And that's going to happen in very few cases. I mean, you're not, and even sometimes when things do violate it, you may, out of prudence, nevertheless accept something. So, for instance, there's a old Supreme Court case called Prigg, which was decided by Joseph Story. And what had happened is that the state had passed a law to make it more difficult for them to enforce the Fugitive Slave Act, right? I'm not fond of the Fugitive Slave Act myself, but basically, Story said that was unconstitutional, right? And there are lots of modern commentators who really condemn him for that and say he obviously didn't understand natural law. And he's, but clearly he did. He was simply saying that, under the circumstances that he was facing at that time, it was prudent to not undermine the law of the Union, because his hope was that ultimately, if the Union held together, right, it would eventually be able to eradicate the whole problem of slavery. So it's not formulaic, it's not cut and dried. We may have some debates over this, we may struggle over this, but we know the general parameters of what it is, and we should be able to know what it isn't, right? And it's not, one good thing about judges is, they have to write down their reasoning. They have to tell you exactly how they got to the point that they reached this conclusion. It's not like a bureaucratic decision. A bureaucratic decision has a beginning, a middle, and an end. You can't figure out how the parts fit together. But a judge is not supposed to do that. A judge is supposed to, you should be able to follow exactly their reasoning and how, and therefore you should be able to tell if it's bogus, right? So you don't need, a formula, because formulas end up being very sterile, and we get the kinds of things, that we've been getting, which we look at it and it doesn't make any sense. And one of the things I really don't understand is, on the one hand, you get majoritarianism, kind of pure and unvarnished. On the other hand, you get, nihilism. And then you still get judges who say to the country, it's up to us to decide what your constitutional aims should be. Isn't that, I can't remember if that's Casey or, it's one of them though, where he says, we determine what the country's constitutional.
We're gonna call the contending sides of a national debate.
Aspirations are, and that's just, now how do you get that from, quote, neutral principles, and in fact, you are, you're doing under these so-called neutral principles, everything you say should not be done. If you're gonna do it anyway, why not have some legitimate basis for that, right? Something that exists beyond just what the judge thinks is wisdom.
And Judge, maybe to kind of, distill, because we're getting near the end of our time here, to kind of distill like what the focus here is that judges are always going to have to exercise judgment when they interpret a document, and that could mean extending an understanding to a novel phenomena. That could mean having to weigh unclear or competing historical evidence. But what it certainly can't mean is disembodying the text from the time and place and circumstances in which it came to be, and the principles that produce it and give it coherence, right?
Right.
Yeah.
No, it can't be untethered, and that's exactly what originalism and textualism was trying to do. Right. It's trying to say you've got to anchor it in the text that you purport to be interpreting. But what we're seeing, and there's just an implosion here recently. I'm seeing so many, there's an internecine war going on the conservative side, trying to figure out what that should be. I don't know what the answer to that is necessarily, but I think it's a helpful discussion to have. I think it's useful, and it's not the first time, by the way. Back in the, I guess, early 60s, late 50s, there was a new conservatism where we had to kind of rethink our premises and start over again. I don't think there's a problem with that, really.
Well, and it also protects against maybe a kind of antiquarianism that's substituting for history, where we can just say, oh, look, well, here's this one historical practice. Let me try to just draw this really attenuated analogy and say, oh, that's just like this thing. But if you have this respect for the underlying principles, if you know the overall nature of the regime, the ends it's going toward, well, then you
Right.
can say, well, that's just an artificial analogy or a misuse of
And
history.
I know that one of the things that's going on now is we want to say that we don't have purposes. We don't have even that. I mean, part of what we think we believe is that the kind of regime that we have here was because of the creature that we have here, right? We know creature of the logos. We've got to explain ourselves, the only one who can make excuses, right? But we look at that and then say, okay, we now are in a time where there is no nature. We don't know what a woman is. We can't, we can't define any of these things. There's a question, I think, as to whether we're really there. But if we thought about that in terms of tradition and experience and the way the world really works, is there objective reality? We might reach different conclusions about that.
Any other questions? Yes.
Thank you. Michael Kaplan from the Public Interest Fellowship. My question is, considering your experience as an appellate judge, what is the difference between how a district court or an appellate judge should approach reviving natural law jurisprudence versus that perhaps of a Supreme Court justice? Because I'm thinking Justice Thomas and his McDonald concurrence kind of sort of leaves breadcrumbs for other judges to follow, but he has that prerogative as a Supreme Court justice.
I agree.
Ultimately, I think all judges, their fidelity should be to the Constitution, but of course the lower court judges are bound by precedent. So how would you
Right.
give recommendations for
Well,
navigating that?
there is, of course, much more room for the Supreme Court justices to, think in those terms and to, design cases to explore that. Most intermediate appellate courts are going to follow precedent, and they will rarely be able to go into business for themselves. They will always be swimming in the jaws of the crocodile, as it were. But they can at least, they can raise some of those issues, even though that may not be determinative. And they have an opportunity to write separately, even, if they may dissent from the holding and therefore explore some of those issues. For district court judges, it's more likely to be at the level of moral reasoning, but they also write decisions. And so they can explain and describe why they're going in a particular direction. Excuse me.
Any questions?
Okay.
Well, Judge, I remember you saying once, if you don't think there's such a thing as objective reality, go up to the top of the building, jump, and see what happens. So thank you very much for reminding us of the facts of life. And thank you all very much for coming. Thank you, Judge.